Good afternoon, everyone. My name is Ana Elizarraga, and I am a Housing and Economic Development Analyst for the City of Evanston. Thank you so much for joining us today. Today we have Phil Devon, Staff Attorney for the Metropolitan Tenants Organization, and John Raffensperger from the Law Center for Better Housing. And they're here today to talk about the changing rules for Evanston landlords and tenants and updates to the residential landlord-tenant ordinance and everything that you need to know. A few housekeeping items. If you see below, you have a small square with a Q&A button. You may submit your questions during the presentation, and we will respond to them at the end of the presentation as time allows. If your question did not get answered, we will be storing those in our system and they will be answered to you via email. We will also have a website available in the city website with frequently asked questions. So we will be taking note of all of your questions and responding to them. And they will be available in about a week or so in the city website for your reference. So without further ado, I'd like to present John Raffensperger, Supervising Attorney for the Law Center for Better Housing.
Thank you, Anna. Thanks to everyone for coming to this webinar this afternoon. I think it's wonderful that landlords in Evanston want to be informed about the changing rules to make sure that that they can stay in compliance and that relations between landlords and tenants can continue in a good vein without unnecessary problems. So I'm going to go through some of the changes that have happened in the last year to the landlord-tenant ordinance in Evanston. If you have questions, like Anna said, you can put them in the box, and we'll address questions at the end so that we can make sure we get through everything. And if there's something that I can't answer and Phil can't answer, like Anna said, we'll take the questions and provide answers through the FAQ or through direct responses outside of the webinar. As I'm sure many, most if not all of you know, being landlords, the Evanston has a landlord-tenant ordinance that governs kind of that landlord-tenant relationship. That ordinance has been in place for quite a long time, and just this past summer, it was amended to incorporate a number of changes that make it more consistent with the ordinances that exist in Chicago and in Cook County more broadly. The new ordinance became effective on January 1st of this year, so it is presently in effect. And so as we're going through this, we're going to talk about, we'll kind of address, questions that landlords may have, and then, talk about the existing law, and then talk about, how that law has changed recently. So the first question that I think many people would want to know is, well, does the landlord-tenant ordinance apply to my property? The answer is probably yes. There are exceptions to the ordinance, but they're mostly for properties that would not be considered like a traditional residential rental unit. So those excluded units would include, units in medical facilities, nursing homes, educational institutions, religious institutions, fraternity houses, sorority houses, hotels and motels where the occupant isn't staying there long term, co-ops that are occupied by the owner, and then also properties that are occupied by a purchaser under a contract of sale. So none of those are really situations that we would consider kind of a classic landlord-tenant situation. I would venture to say probably none of the units that any of you are renting likely fall into those categories. So the updates would also include in that excluded category units in licensed transitional facilities, shelters, and shared housing facilities of that sort. The more important change is if you do have an excluded unit, under the new rules, the landlord does have to disclose in the marketing materials for renting that unit that it is excluded from the landlord tenant ordinance. And that has to be stated in the application materials in a prominent sort of way. So if you do have a unit that falls into one of those exceptions, you would have to say in your marketing materials and put it in a noticeable place in your application that it is an excluded unit. And then also there was a change under which purchasers occupying units under a contract of sale and long-term hotel and motel applicants also do get the benefit of the anti-lockout provisions, which we'll discuss more in detail later. Again, likely none of this applies to any of you, but if it does, probably the most important thing to remember is the disclosure requirement. The next question we're addressing is, okay, we're at the start of a tenancy, the RLTO does apply. What terms can the landlord include in the lease? Under the existing rules, the ordinance required that a lease be in writing, and it has to contain the full names and birth dates of the occupants of the unit. So it's a pretty broad, basic requirement. Under the new ordinance, there are a number of terms that have been deemed kind of unfair and not allowed to be included in a rental agreement that starts after January 1st of this year. So if you have an existing lease with somebody that's in force that was signed before January 1st, and it has some of these terms in it, those terms are probably still enforceable. But if you're starting a new lease with a tenant in 2025, you have to make sure that these terms are not, in the lease you're using. And just before we even get into it, if you're looking for additional guidance on that, there is a model lease available through the City of Evanston's website. If you just Google Evanston landlord tenant, that page will come up and there'll be a link to the model lease. So what can't be in the lease? The lease can't require the tenant to give up the right to receive appropriate notices, like notices of termination or notices for non-payment. The lease can't make the tenant give up the right to a jury trial if there's a lawsuit relating to the lease. A lease can't prevent a tenant from saying negative but true things about the landlord of the building. That doesn't mean that a tenant can say false things. That would fall under, defamation law. But a landlord in a lease can't tell the tenant, no, you can't, post on social media or say things to a reporter or something like that about true things that are happening in the building or with the landlord-tenant relationship. The lease can't limit the tenant's right to contact law enforcement for emergency assistance. So there can't be anything in there about not calling the police. The lease can't require the tenant to pay the landlord's attorney's fees if there is any kind of dispute relating to the lease. A number of form leases do include an attorney fee shifting provision, so it's worth looking to see if there's one in your lease. Lastly, this may not be in the ordinance, maybe in another place in Evanston law, but leases cannot prohibit specific breeds of dog if the rental agreement otherwise allows dogs in the property. So, most commonly, you can't have a breed exclusion like for pit bulls, if pets are allowed in the property generally. So important to note, if you do use a lease with prohibited terms, you might be liable for 2 months rent and damages. That may not be true in every case, but it's certainly a possibility under the new law and something that landlords should be aware of and take seriously. So going on from the lease itself, what rules can landlords have for tenants living in their property? So under the existing law, any rules that the landlord wanted to have had to be in writing, and they had to be disclosed to the tenant at the time they entered into the lease. So oftentimes you'll have a lease and then you'll have a separate rules and regulations document. The rules had to be reasonably related to promoting the convenience, safety, and welfare of the tenants in the premises, preserving the landlord's property. So, the rules have to be about, keeping people safe, protecting other tenants, or protecting the property itself. You can't have arbitrary rules that don't serve those purposes. The rules have to be applied to all tenants in a fair manner. So, I mean, you couldn't have a rule that, the tenant in unit 2A cannot use the common area that other tenants can use or something like that. And the rules have to be explicitly stated so that the tenants are fairly informed about what's expected. So, having a rule that says something like, for example, no disruptive conduct or something like that would probably be too vague. You'd have to say exactly what tenants are allowed to do or not to do. The updates here, just add, it's kind of a minor update, but it adds that rules and regulations cannot be imposed for the purpose of preventing tenants from assembling in the property or from communicating with one another about the property. So this is basically about buildings where, tenants might want to meet to talk about building-wide problems, possibly talk about coordinating efforts or forming a tenants union or something like that. That can't be prohibited in the rules. And, I think that comes up again later when we're talking about retaliation. It's not something that landlords can retaliate against tenants for either. So continuing on with things that kind of would come up at the start of a tenancy, what fees can landlords charge to tenants, for applications and kind of starting out with a new lease. So under the prior ordinance, there were not really any limits on fees a landlord could charge tenants and include in the lease. So what's changed? Well, beginning, with leases, beginning this year, the lease cannot impose a late fee of more than $25 if the rent is below $1,600 or below. And if so, there's a 25, if the rent is 1,600 or below, the limit is $25. If the rent is 1,600 or is above 1,600, then the limit on a late fee that the landlord can charge for late payment of rent would be $25 plus 5% of any amount above 1,600. So, for example, if the rent was $1,700, the maximum allowable late fee would be $30 because it'd be the $25 plus the 5% of the 100. So, it's important to remember there is now a limit on the late fees you can charge. Most late fees, I think, probably would already fall within these limits, but it's certainly good to check. The lease cannot require the tenant to pay certain fees like application fees, credit check fees, and move-in fees that are in excess of the reasonable cost of that expense. So what that means is if you're going to charge somebody a move-in fee, that move-in fee has to actually reflect the additional costs that the landlord has to pay to prepare the unit and maybe operate the service elevator, things like that. Actual identified costs that the landlord is incurring associated with the move-in process. And if there is a move-in fee or an administrative fee of that kind, the landlord does have to provide the tenant with an itemized list of the costs that comprise those fees. So you have to inform the tenant, this is why you're being charged this fee. This is what we're paying for that you're covering as part of the move-in process. And that fee can't charge the tenant for costs associated with routine maintenance and upkeep of the property. So, for example, if the unit, just needs repainting, because it hasn't been painted in a long time, that's, routine maintenance. It's not something that you can charge the next tenant, as an element of a move-in fee. It has to be something specifically associated with that process of moving in or the process of checking credit or checking references, things like that. So this is a big change that is going to affect what a lot of landlords are doing. A lot of landlords charge move-in fees, application fees, credit check fees, and this is going to be a new practice. So, kind of thinking about as early as possible, okay, what is my additional expense of this thing? Maybe create a document that explains that. That'll help you be in compliance with the new rule. Again, just like with the prohibited lease provisions, if you include in your lease fees that shouldn't be there can be 2 months rent and liability if it ends up in court. So it's important to know. So, one thing that we've seen a lot in recent years is landlords going to these non-refundable fees in lieu of security deposits. The changes to the ordinance, I believe, kind of create an opportunity to shift back towards security deposits because it makes security deposits easier in Illinois, just like it has in Cook County more broadly. So what are the existing rules around handling a security deposit? So this is the ordinance as it's always been. The landlord can't charge more than 1.5 times the monthly rent. If the landlord charges more than 1 month's rent, the tenant has the option of paying it in installments rather than all at once. The landlord is required to hold the security deposits in a federally insured bank account in banking institution in the state of Illinois, and they have to keep it separate from their other accounts. So, this isn't a change. This is how it's always been. You can't what they call commingle those assets. So you can't just put a tenant security deposit in the landlord's regular bank account. It has to be held separately because it's still the tenant's money legally. The landlord has to return the security deposit within 21 days of the tenant moving out, unless they are applying that deposit to appropriate costs. And the appropriate costs are money that the tenant owes as rent or money to repair damages to the unit beyond ordinary wear and tear that the tenant has caused. So that basically means if the tenant broke something, that was in good condition, that's the kind of thing a security deposit could go for. If the tenant leaves a bunch of junk in the unit that needs to be removed, things like that. But again, if the unit just needs to be painted, or if the carpets are old and need to be replaced, or there is just normal wear from a person living in the unit and using it responsibly, that's not something that a deposit can be applied to. And then if the landlord is withholding any part of the security deposit, they're required to provide an explanation for the amounts withheld within 21 days, so that the tenant knows why the deposit is not being returned to them. So what's new? So previously, there were rules in the ordinance around interest on security deposits. So because the landlord's holding the deposit in a bank account, that earns usually a very small amount of interest, and the rules required landlords to account for that and pay that interest to tenants. That was changed in the ordinance because there are these new rules around fees. It seems, I believe it was felt that the deposit rules should be, the interest is such a small amount that it's not worth the hassle that landlords were having to go through to account for, what was often just, less than $1 in interest and pay it to the tenant, write a check and things like that. So landlords are no longer required to pay interest on security deposits. The other change is just to make it very clear that if you're taking a security deposit as a landlord, you can't avoid the rules around security deposits that we just discussed by calling it something else. So, if you're taking a month's rent from a tenant, effectively a security deposit, you can't just call it like a non-refundable fee and then not put it into your own bank account or just not return it to the tenant, things like that. You can't get out of the rules by calling things something that they're not. So what information do landlords have to disclose to their tenants at the start of a tenancy? So we're still kind of in that tenancy formation stage. So under the pre-existing ordinance, landlords had to disclose the owner or the manager's name, address, and telephone number. And then if the ownership changed, they had to provide the new information for the new owner, so that the address and the telephone number for the successor. Under the new ordinance, there are some additional disclosures that landlords have to make at the start of a tenancy or when a tenancy is renewed. So they have to tell tenants whether the landlord or the tenant is responsible for paying utilities and the utility costs for the last 12 months, so that the tenant has an idea of like, what am I going to have to be paying for heating or electric, things like that. Kind of avoids problems by letting people know up front what they should expect. Landlords have to disclose any building code violations that were found within the last year. And they have to disclose if the city or utility company has threatened to terminate utility services for the building. So again, this is just about letting tenants know up front, have there been problems in this building that tenants should be aware of? Is there a risk that the utilities may get cut off, like particularly water service, through no fault of their own? Landlords have to disclose lead hazards. I believe that they were already required to do that, maybe under federal law, but it's now in the ordinance as well. And if there's a foreclosure that's being threatened or is going on, again, just so that tenants are aware, if there may be an unexpected change in the ownership of the property due to a foreclosure process. And then finally, landlords have to inform tenants, usually by a handout, how to detect, report, and remediate bed bugs. And that's in everybody's interest. We want everybody to know how to identify and deal with bed bugs. So, once the tenancy is formed and then the lease is underway, what obligations does the landlord have to maintain the unit? So to make repairs and do upkeep. So under the existing rules, the landlord, is required to maintain the property in compliance with the building code and in other, city and, state ordinances and laws. And it's important to note, the landlord has that responsibility to maintain, and they can't just give it to the tenant by saying in the lease that the tenant's responsible for maintaining things. If the tenant is going to be made responsible for making repairs or doing upkeep, there has to be a separate written agreement to that effect, in which the tenant receives some kind of compensation for that. They can't just be a normal term of the lease that the tenant is responsible for doing the landlord's job there. The landlord is also required to address criminal activity on the premises that threatens the peaceful enjoyment of the property by other tenants. So, if there is criminal activity going on, the landlord does have a responsibility to, have something done about that. And then if the agreement requires it, so if the landlord has taken responsibility for providing utility services, or other kinds of what we would call essential services like hot water, telephone service, cooking gas, things like that, the landlord has to supply those things in a steady and ongoing sort of way. So what's new? Well, really the only change here is that the definition of essential services has caught up with the times a little bit to include air conditioning and internet service. So again, if the lease provides that the landlord's going to provide internet access or they're going to provide central air, those things are considered essential services that have to be maintained. And there are kind of special rules for how, problems with those services can be dealt with. Generally, they just have to be fixed more quickly, and the tenants have more remedies if they're not fixed. So can the tenant make repairs to their own unit without going through the landlord? So under the rules as they existed prior to the amendments, if the landlord does not do their job and maintain the property in compliance with the code, and the tenant notifies the landlord in writing that that's the case, that there are problems with the building that are, that should be fixed, and the landlord doesn't correct the problems, the tenant does have the right under the ordinance to have the work done by a professional. And if they provide the landlord with the paid bill for the work that was done, they can deduct the costs of that work from their rent. Formerly, the limit up for that for tenants doing that was 1/2 of the rent or $200. That's gone up to now $500 or 1/2 of the rent. The other change here is that formerly the landlord had 2 weeks after receiving written notice to make those repairs before the tenant could what we call repair and deduct, so make the repairs themselves and deduct from the rent. Now the landlord has to address those conditions within 10 days, which is the same amount of time that tenants are required to remedy breaches of the lease. So it's kind of made it consistent between landlord and tenants how much time they have after receiving notice to fix a problem. So how about withholding rent? If the landlord doesn't make repairs to the unit, can tenants just withhold rent without actually making the repairs themselves? So the ordinance requires a number of things to be true before a tenant can do that. They can under certain circumstances, but they're pretty limited. If the landlord, again, doesn't maintain the property the way they're supposed to, the tenant notifies the landlord in writing that's the case. 10 days go by and the problem's not corrected, and the condition has been cited by the city as a code violation. Under those circumstances, yes, the tenant can withhold an amount of rent which reasonably reflects the reduced value of the premises. So, what that means is kind of unclear. It basically means, hey, whatever the reasonable amount, what's a reasonable amount that you should take off to account for the problem. So, for example, if there's a leak that makes one of the rooms of the home unlivable, well, what would be appropriate rent for a 2-bedroom rather than a 3-bedroom might be a way to think about that. But the law is kind of intentionally vague on that point because it's really not clear in a lot of cases how something would reduce the value. But the important thing to remember here is that the tenant can withhold rent, but it does have to be something that's been cited by the city as a code violation. And again, now the landlord has 10 days to respond to those notices rather than 14. Can the landlord enter a tenant's rental unit? The answer is yes. It's been yes under certain conditions. So the landlord has to be entering the unit for a legitimate purpose. This is now a space that the tenant is paying for, and so the landlord can't just go in whenever they like. So the landlord can go in to if there is a need for an inspection, those inspections can't be so frequent as to be harassing to the tenant. So it has to be a real need for it. The landlord can go in to make necessary repairs to supply services. So like if there's a problem with the water or with the gas or something like that, or to show the unit to prospective purchasers. So if the landlord was selling the building, then that would be a legitimate reason to go in if they need to show it to somebody who might want to buy it. Under the existing rules, the landlord had to provide 2 days notice to the tenant of their intent to go into the unit. So if the landlord does have a legitimate purpose and it's not an emergency, the landlord does need to give the tenant 2 days notice. So in writing, or by some other means, intended in good faith to let the tenant know what's happening. So it could be a text, it could be a call if the tenant actually gets the call. There could be a number of ways that could be accomplished. Really, it's just letting the tenant know, hey, somebody's going to be coming into your home, and here's why. And then if there is an emergency, if there's a burst pipe and there's water flooding the building or something like that, or there's some emergency reason the landlord needs to get in, they don't need to provide the 2 days notice, but they do need to let the tenant know after the fact. So again, we're talking about what the law as it was. The changes here are relatively minor ones or clarifications. So it is a legitimate purpose for a landlord to go into a unit to show it not to a prospective purchaser, but to someone who might rent the unit within 90 days of the end of the lease. So, if the lease isn't being renewed, the landlord or the tenant has decided they don't want to continue the tenancy, or it's not clear yet, there hasn't been a renewal, the tenant's still thinking about it, the landlord can show the unit to somebody else and can enter for that reason. If in order to be reasonable, the entry does need to be during an appropriate time of day. So it clarifies that if the landlord does need to go in, they should go in between 8 a.m. and 8 p.m. Or if the tenant agrees to some other time, that can be okay as well. But just the presumption is, to be reasonable, it has to be during the time when most people are awake. And then if the landlord does enter for an emergency reason, it does clarify that the landlord, while they don't have to give notice before, they do have to provide notice within 2 days after the entry that they did go in. So they have to be upfront with the tenant that, I went into your unit, for this reason, to address this issue. So a big question for a lot of landlords, what can you do if the tenant doesn't pay rent? So it's always been the case under the Evanston ordinance that if the tenant doesn't pay rent on time, the landlord can give that tenant a 10-day notice, which is basically a notice saying, hey, you haven't paid your rent on time. Here's what you owe me, and pay it within 10 days, or your tenancy is going to be terminated, and the landlord can go ahead and file an eviction case if they want to get the tenant out. So what's changed? So there have been some clarifications to this, and then one very big important change. So the the notice has to be delivered, and this is just a clarification of the ordinance, by in the ways that the Illinois Eviction Act says it should be. So I've cited the section here. It's section 211, and that basically says that there are 4 ways that a landlord can serve a termination notice. They can give it to the tenant personally, meaning they hand it to the tenant, put it in the tenant's hands. They can give it to someone else who lives in the property, who's over the age of 13, a member of the family. They could send it by certified or registered mail with return receipt. So again, it has to, you can't just send it by regular mail. You have to send it by certified or registered mail with proof that it was actually delivered to a person. Or if the tenant is not living in the property anymore, if they've gone somewhere else, they're not present anymore, it can be posted on the property, meaning stuck to the door, put in the door, put under the door, taped up, something like that. That is a problem that a lot of landlords run into is, once there is some friction between landlords and tenants, very understandably, sometimes you don't want to have those face-to-face interactions, and landlords will put notices up on the door or something like that, or stick it under the door while the tenant is still living in the property and they know they're still living in the property, and that can cause problems down the line in eviction cases. So, I think this is actually a really good clarification so that everybody knows, okay, this is how these things should be done. The new ordinance also says that all tenants in units under the landlord tenant ordinance are entitled to 10 days notice. There's no more exception for owner occupied 2 flats. It used to be the case that, if the property owner lived in the property and it was only 2 units, then I think they only had to give 48 hours notice, an opportunity to pay the rent. That exception is now gone. It's 10 days for everybody. The ordinance makes clear that if the landlord chooses to accept the rent after that 10 days has passed, then they're reinstating the tenancy and they can't evict the tenant. So, if the tenant's late and the landlord takes the rent anyway, they can't take the rent and then also continue forward with an eviction process, because it's after the time stated in the notice. And then this is kind of the big, change that, again, brings Evanston into line with Chicago and Cook County more broadly. Once per tenancy, meaning once, for a person who's living in a particular unit, the tenant can pay the rent due plus legal costs, but not attorney's fees, to the landlord after the expiration of the notice. And the landlord has to accept the money. It's not a choice. So that can happen, while, after the notice has expired, but before an eviction has started. It can happen after an eviction case has been filed, and then that eviction would have to be dismissed. The only point where that right gets cut off is, if the court enters an eviction order saying that, the landlord is entitled to the property and the tenant should be evicted. After that point, the tenant no longer has that right to, what we would call pay and stay. But before that, if the tenant, contacts the landlord and says, hey, I've got the money now. And, if you filed a court case, I'm also going to pay you, the cost that you spent to file the case and the cost that you spent to get service on me. I'm ready to pay you all that money. Then the landlord doesn't have a choice. They have to take the money and they have to dismiss the case. Now, if the tenant does that again the next month, then the landlord is not required to accept that money. So it is once per tenancy. That doesn't mean once per lease year. That means if the tenant is living in a property, until they move to somewhere else, they get to do that one time. Aside from non-payment of rent, what can the landlord do if the tenant breaches the lease in some other way? So under the existing ordinance, if the tenant violated the lease in an important way other than not paying rent, the landlord was required to give the tenant a 30 days written notice, an opportunity to fix the problem. The tenant has the right to fix that problem within that 30 days, and if they do, then they can continue living there. If the problem happened again during the term of the lease, then the landlord didn't have to give them an opportunity to fix it. They could just give them another 30-day notice in writing, and then they would have to move out or be subject to eviction. So what's changed? Not much, but the new ordinance just clarifies that if the landlord gives that 30-day notice and then accepts the rent after those 30 days have run, then that's basically the landlord saying, you know what, it's not that big a deal after all. I'm continuing the tenancy. So landlord should be aware that if the tenant's doing something that's so bad that they really don't want the tenant to continue living there, once they have knowledge of that problem, they shouldn't be accepting rent for rental periods after they know about it, unless the tenant fixes it. Because that is legally an acknowledgement that, you know what, I still want to continue this tenancy. Landlords also shouldn't take actions that are that would serve to accept the tenant's conduct that's in violation of the lease. So I think a very common example of this is pet policies. If there's a no pets policy in the building, but the tenant has a dog and the landlord knows about it, and the tenant has the dog for 6 months, a year, and the landlord doesn't say anything or do anything about it, the landlord can't then later go on and say, well, you know what, it's against the rules to have a dog, so now I'm going to kick you out because you have a dog. So the landlord, can't, what we would call, acquiesce in the lease violation. And then finally, just like with the 10-day notices, and this should say 30-day notices here, this is a typo, but all tenants in Evanston are entitled to that 30-day notice if there's a lease violation. There's no more exception for the owner occupied 2 flats. So what happens then when the lease runs out? What should the landlord do then? If the landlord doesn't want to renew the lease, they've always had to notify the tenant in writing that they didn't want to renew the lease. If the landlord does want to renew the lease, they've always been required to offer the tenant the proposed lease in advance of the end of the tenancy. So what are the new rules here? So the landlords now have to give the tenant at least 90 days advance written notice if they're not going to renew the lease. So, if the end of the lease is coming up, they, essentially 3 months ahead of time, if the landlord doesn't want to sign a new lease or continue the lease, they have to tell the tenant, hey, I'm not going to have a new lease with you, so you need to get working on moving out. If the landlord does want to renew the lease, then they have to give the tenant the proposed new lease at least 90 days before the end of the lease term. And that's, so the tenants have enough time to decide, okay, if my rent's going up, do I want to pay it? Am I going to be able to afford to live here? If not, again, it's giving tenants appropriate time to move. And then finally, tenants can't be required to commit to renewing the lease more than 45 days before the end of the lease term. So, if the landlord does offer renewal and they offer it 90 days ahead of time, the tenant has that, essentially a month and a half to consider. The landlord can't make them make a decision on it before 45 days prior to the end of the lease. They can, if at that point, the landlord can say, okay, it's 45 days before the end of the lease, you need to decide, are you staying or are you going? And then the tenant does need to make a decision. So kind of moving on to some other problems that can exist in tenancies. So what kinds of actions of a landlord would be considered retaliatory? And that means, essentially the landlord is improperly punishing the tenant for exercising the tenant's rights. So under the ordinances that existed before the amendments, the landlord can't retaliate by terminating or threatening to terminate the tenancy, increasing the rent or decreasing services, like building services, utility services, etc., or threatening to evict the tenant or actually evicting the tenant, or refusing to renew the lease in reaction to a tenant making a complaint or exercising legal rights. That's still the case. The ordinance just now is more specific about, the situations where the landlord can't do those things, can't terminate the tenancy, can't raise the rent or refuse to extend the lease. So things that, conduct that would be considered protected, under the new ordinance would be things like complaining of code violations or landlord practices to a community organization in the news media. So now it's not just, oh, the tenant complained to the city. Well, if the tenant complained to a reporter, that would also be protected, or to a community organization. A tenant would be protected for organizing in the building, so distributing leaflets or asking for permission to use building common spaces, for tenants to meet and talk about issues in the building, form a tenants union, that is also protected. Tenants who testify in a court or administrative proceeding, that would also be protected conduct that the landlord cannot retaliate against. And then lastly, exercising or attempting to exercise rights or remedies under the Illinois Safe Homes Act. So that applies to people who are experiencing domestic violence. And they may have certain rights like, maintaining, leaving a lease early, or maintaining a rental rate or something like that. Those are all, that would also be protected conduct. And kind of relatedly, what kind of things would constitute an unlawful interruption of tenancy? So this is not the landlord retaliating by doing something that would be otherwise lawful for them to do. This is sort of a landlord trying to force a tenant out by doing something unlawful. A lockout is defined kind of broadly. Mostly we think about that as, okay, the landlord has changed the locks and the tenant can't get back in the unit. But it does include a lot more things than that. It would include, plugging the locks, filling them with glue or something like that, changing or removing locks. So if you take the locks off, that's still a lockout, even though the tenant can get in. Now they can't secure the unit. Blocking the entrance to the unit with boxes or appliances or furniture, removing any doors or windows. So you'd be surprised. I've seen cases where landlords will take off the doors, take out the windows, and expose people to the elements because they want them to leave. Interfering with essential utility services. Removing the tenant's property from the unit. So if you take things and put them out in the hall or on the curb, that would be considered an illegal lockout. And in any case where the landlord's using force or threat of violence or injury to force the tenant out. So if you're threatening the tenant, going there saying you're going to beat them up, or going there with a gun, things like that. In addition to the above, under the new changes to the ordinance, the landlord can't interfere with internet service. And they can't remove or incapacitate appliances or fixtures except to make repairs. So this is basically a recognition that internet service is something we all need now to operate our daily lives. It kind of also recognizes situations where, if the landlord might take out a refrigerator or disable the stove, things like that. Again, these are all things that are designed to essentially make the unit unlivable for the tenant, to force them to leave outside of a lawful eviction process. Landlords can't do that. They can be subject to fines and legal liability. They could be sued. So we've included here some resources. I've been told these links are not working, so I believe Anna is going to put the links to these materials in the chat. I think that's all I've got for today. We I've tried to kind of move through these changes to leave us some time for questions at the end.
Thank you, Jonathan. So now we will be going through the Q&A. And all of these resources are in the link that I shared in the chat. So first question asks, in regards to the change in late fees, a resident has countersigned lease with a different late fee payment amount, and the late fee payment structure was recently updated to the new ordinance. Would the signed active lease or the new ordinance take precedence?
If I understand the question correctly, if the rental agreement was going into effect after, on or after the first of this year, whenever the document was executed, I believe it would be the new ordinance. Because generally, it becomes effective, the landlord offers the lease, the tenant signs it. So if the tenant signed the copy with the new language and it's a tenancy starting in January, I would say the new ordinance. It's possible I did not understand the question correctly though. So please ask a follow-up question if I missed that.
Thank you. Next question asks, how does the RLTO handle fixed 3-month rentals? One, so it's multiple questions. So I guess we can start with that one. How does the RLTO handle fixed 3-month rentals?
Okay, so I'm interpreting that as a rental, like a lease for a term of 3 months and not a year. That I don't think the rules would be any different. The RLTO still would require a written lease for that. But there's not different treatment of a lease that is for a month to month or for a term of several months rather than a year.
Next question is, how do I deal with a 90-day renewal notice requirements?
So I think that what I'm hearing that in that question is, okay, what are the mechanics of that? How would I provide 90 days notice? And and that just needs to be noticed in writing, that the landlord does or doesn't not intend to offer a renewal. And if the landlord is offering a renewal, then they would need to send the proposed lease to the tenant at least 90 days before the end of the tenancy. So, that could be a letter, that could be, in some circumstances, maybe an email with an attachment. It would just need to be written notice of the landlord's intention. And just in general, you're going to want to be able to prove you did that. So you should do it in a way that's documented, so that if you do end up needing to go to court because the tenant doesn't move out or something like that, and you don't want to renew, you've got evidence that you did comply with the rules.
Next question is, am I allowed to non-renew without any notice or penalty?
Without any notice. So under the new ordinance, no, you would not be able to decline to renew a tenant without giving them that 90 days advance notice.
And the next question is, am I required to use a sample lease for a 3-month lease?
Are we reading that as model lease? I'm not sure what the sample lease is. I don't believe anyone is required to use the model lease. That's offered by the city as a convenience to landlords who want a lease that they know is in compliance with the ordinance. Landlords can use their own lease if they but they are then responsible for making sure it complies.
Next question says, what about extensions to leases that were originally created before January 1st?
I'm not 100% sure about this one, but I believe that if you're extending a lease that was entered into before January 1st, the extension would need to comply with the ordinance. So if you're renewing, you would need to renew on a lease form that's compliant. I don't think you just grandfather in a tenancy for as long as it lasts because it was entered into before January 1st.
Okay. Next question asks, can you explain the first line in the fee slides? It was very confusing.
The first line in the fee slides. So let me look that back up. Okay.
The late fee.
The late fees. That looks like the first line. So yeah, it is a little bit confusing. This is the same way that the Chicago and Cook County ordinance handles late fees. And it basically just says below a certain level, there is just a maximum late fee that you can charge. So if the rent is, $1,600 or less, for the unit, then the late fee cannot be more than $25. If the rent is more than $1,600, then, the maximum amount is that $25 plus 5% of any amount that the rent is over 1,600. So, I think the example that I gave was if the rent is 1,700, the amount that's over 1,600 is $100, and 5% of that would be $5. So, the maximum late fee you could charge is the $25 plus the $5, it would be $30 maximum late fee. So, in terms of expressing this in a lease, a lot of Chicago leases for a long time have just stated, essentially copied the ordinance language for the maximum late fee rather than doing the calculation. I think that's probably okay. Just make sure that you're actually not charging more than that. You would be surprised how many landlords charge unlawfully high late fees, even though in Chicago, that's been the law for quite a long time. And it can cause them problems down the line.
Next question. Regarding fees, do we need to itemize our expenses for credit reports, etc.?
Yeah, I believe that is one of the things that would need to be, well, it says move-in fees and administrative fees. So credit check fees, I think, are a little bit easier because I think the cost is more straightforward. I think, most landlords use a service for that. And they're charged a certain amount for pulls, or if they're charging a monthly rate, I think, you could, I'm just kind of talking off the top of my head now, but you could probably just, say, okay, well, we have on average so many applications a month, we pay such and such monthly fee, just divide it up, something like that. I think just the important part is, being ready to defend it. I would have to go back and look at the ordinance language to see if if credit check fees are called out as needing to be itemized. I don't believe that's the case, but, you can check it. It should be pretty clear. I think it's more about itemizing when it would not be as clear as that. It would be like a move-in fee, or, sometimes you'll see just a quote unquote administrative fee, and where it would be completely unclear to the tenant what this money is being spent on. I think for a credit check fee, it's being spent on a credit check.
Next question.
And just as
Sorry.
one thing to add on that topic, I am aware of, I believe, and correct me if I'm wrong, Jonathan, but I believe it was passed, there was an amendment to the Landlord Tenant Act that gives tenants the right to use a reusable credit check. And that's if they supply it to the landlord at no cost, then it's directly available to you. I just want you guys to be aware of that. So if a tenant comes with their own credit report for use in this application process, that you're aware of this, right? And can allow that. And I'll put something in the chat here about that specific.
Thanks, Phil. That'd be really helpful.
Okay, next question is, I've seen the model Evanston lease. Can we use the NAA lease, or are we required to use the Evanston lease?
Yeah, and I think we addressed this question a little bit earlier. Landlords can use a different lease. They're not required to use the Evanston model lease. You would just want to make sure that if you're using a different lease, that it does comply with the requirements of the new Evanston ordinance, so that you're not in violation of that provision and subject to damages.
Next question is non-renewable a prohibited term to use in a lease? And does it entail damages?
I'm guessing maybe are they asking if a lease says upfront that it will not be renewed from past the original term? I don't believe that is a prohibited lease term, but I may be misunderstanding the question.
In 2021, this is the next question. In 2021, I charged my tenant a small moving fee in lieu of a security deposit. Do I need to change this when we resign the lease in August of this year?
No, unless you're charging the tenant another move-in fee, but I imagine if it's the same tenant in the same property, the tenant isn't moving in again. So as long as, you're not charging a new fee, then that should be fine. Certainly there weren't rules before about move-in fees versus security deposits or any of that. So.
Next question is supplying internet access the same thing as paying for it?
So in terms of, providing an essential service, I think, that is where the landlord is paying for internet for the building and giving it to tenants. I think in terms of the retaliation issue, if the landlord is interfering with the tenant's own, the service the tenant is paying for, then that would still be retaliation. So, the landlord can't, cut the tenant's internet cable or something like that. I think it could be potentially an essential services issue if the tenant is paying for internet and due to some building issue, the tenant's not able to receive the internet access. But I think that would be kind of case specific.
Yeah, and I would just add, I don't think supplying it is necessarily the same as paying for it, but I would definitely make it your best practice to very clearly articulate in your lease who is responsible for paying for the internet service and whose name it would be in, and just stating that
Yeah.
supply, but it's up to them to connect and pay.
Well, and it's coming to mind now. I mean, there are some buildings where the landlord requires tenants to get their internet through a designated provider, and the building has infrastructure in place for that. In that sort of situation, I would think that supplying the internet would be providing an essential service there, because you're essentially taking responsibility for providing it to the unit. But I mean, I don't think it would necessarily be the landlord's problem if there was a provider outage or something like that. It's more, if there's something wrong with the building, the infrastructure in the building for getting the internet to the unit.
Next question says, does an email count as in writing?
An email can count as in writing for some things. I think for like notifying a tenant of an intent to enter, or providing notice of non-renewal or things like that. I mean, that email can be okay for that, provided that the tenant's getting it. I think the problem that that people often have is, people have different email addresses. They don't always check them, things like that. So, if you're going to send things by email, you want to make sure it's an email address that the tenant's using and is receiving those communications. So if you communicate regularly with your tenant via email and it's a good address, then that can be okay. But in terms of the legal effective notice, it's effective when it's received by the person. So, if you have a question about whether an email address is being checked, or, if the tenant, if it's an old one or one that the, tenant has shut down or something like that, having sent it to that address is not necessarily good enough. You'd have to show that the tenant actually got the email. So, if there's any question about it, I always recommend that people, serve by some other means that they can prove it's received, like handing it to a person, or, sometimes text is better, or sometimes, you want that registered mail or something like that, if you want to have clear evidence that it's been received.
Yeah, I think that's a great best practice. And what I always tell folks is I think it's good to, follow up or send a letter, and then you can send the same via email, confirming that you just mailed it, and you may text it as well, or whatever means you have to send it. I think just sending it as all the ways is probably a best practice.
Yeah, really, you're just trying to prevent a situation down the line where somebody is saying, well, I never got that. And then you want to be able to show, well, I emailed it to you, but I also sent to you a letter. Here's the proof I sent the letter. I also texted it to you. I also, had somebody skywrite it above the building, whatever it may be.
Okay, and then we have enough time for one last question, but I'd like to remind everyone that this is just a first of a series of webinars that will be available. And all of the questions that did not get answered will be added to our frequently asked questions list, which will be posted on the city website. So this last question asks, what if a tenant is month to month? What kind of notice do you give them other than a 30 days notice?
If we're talking, I assume about notice to not to renew a tenancy. That would be under the new rules, that would be a 90-day notice because you're not renewing the tenant's month-to-month tenancy. So you have to give them 3 months advance notice if you're going to do that.
So I think that's all the time we have today. Thank you very much, Jonathan Raffensperger and Phil Devon from the Law Center for Better Housing and the Metropolitan Tenants Organization. And thank you so much for everyone that attended. Again, my name's Ana Elizarga, Housing and Economic Development Analyst at the City of Evanston. If you have any questions, you may ask them at through our Evanston 311 system. That's another way to get answers to your questions. But we will be posting a frequently asked questions document in the recording of this webinar at the city website. So thank you so much, everyone. Have a great rest of your day.